Hello, welcome everybody. Thank you for being here with me today to this immigration overview and Ask Me Anything presented by Alcorn Law. It's great to be here with you. My name is Sophie Alcorn. I'm the founder of Alcorn Law, and I'm looking forward to being here with you today, sharing my thoughts and answering your questions. So I see that some folks already put their anonymous questions in the Q&A panel, so you're welcome to continue to do that, and I'll answer as many as I can today. We are scheduled to be together for, I believe it's an hour. Let me just check. Yes, we're scheduled to be here until 1 o'clock Pacific time, and I'll try to answer as many questions as I can. And first, I'll share some slides with some updates on what's going on in immigration. Our standard disclaimer here, this presentation is an educational service by Alcorn Immigration Law. All information discussed should not be construed as legal advice for any specific action and is an overview only. Please be sure to consult a knowledgeable professional for assistance with your particular issue. You'll see the QR code. That is a link to be able to connect with us and complete our questionnaire so that we may be able to book a consultation together. And I'll be sharing a little bit more about our services and availability and expertise throughout today's webinar. So our mission at Alcorn is to really help founders and the world's most brilliant immigrants find a way to live and work legally in the US and contribute your services, talents, and skills to our economy. And we do that by helping people overcome borders, expanding opportunity, and connecting the world by practicing compassionate, creative, and cutting-edge immigration law in service of the betterment of humanity. It is easier for me to monitor the Q&A panel, so I would encourage you, please, instead of using the webinar chat window, there's a function in Zoom, which is called a Q&A feature, and it allows you to ask your question anonymously as well. So if you could try to put your questions in there, I would really appreciate it. It'll help me answer them more easily as we go on throughout today's webinar. By way of background, I'm a lawyer. I practice immigration law. I do that to help really smart people come to the US and live here and work here. My dad was an immigration lawyer. I founded my law firm 10 years ago. I'm having a little bit of allergies right now, so forgive me if I'm a bit sneezy. But we're gonna get through and we're gonna try to answer all your questions. And I'm very much looking forward to helping you. I believe the world should be a place where each child that's born has the opportunity to self-actualize and lead a good life and contribute their skills back to the world and be in their flow state. So that's one of the things that motivates me with the practice that I have. So let's start with an immigration overview. There have been a number of recent policy developments, and they've been affecting a lot of things. And we have some information. There's other information we don't have yet. Some of it's still emerging. And there's a lot in flux. There's absolutely a lot in flux right now. So I would say top of mind today, we're still in a government shutdown. 2 weeks. It's a long time. That means that Department of Labor is not processing labor condition applications for new H-1B transfers, petitions, concurrent, cap exempt, whatever. New LCAs cannot be obtained. And also PERM is stalled for the prevailing wage determinations and the 9089 labor certifications. So H-1Bs, if you already have an LCA, can happen, and green cards, if the PERM is done, can happen because USCIS and the Department of State are functioning as they are fee-based agencies, but Department of Labor is not. So that's a big effect of the government shutdown. It kind of dovetails with the H-1B announcement a couple weeks ago. When was that? That was like September 19th, I believe, and it took effect on September 21st, I think. That was the $100,000 fee rule. So that we've had a good victory on that. We had a client who needed to file their H-1B transfer case the day after that went into effect. And his approval came in over the weekend with premium processing with no $100,000 fee, no request for evidence. And we still don't know how to pay the $100,000 fee. So even if he had $100,000 that he had wanted to pay, we wouldn't have known how to do that yet because it hasn't been announced still. But there was no request for it. And just to put that into context, that was somebody who already had an H-1B. They were completely leaving their corporate job to only work for their startup. And this is kind of good news too for founders. Actually, it's excellent news. They were requesting an 18-month H-1B as the 100% owner of their startup to be the CEO, and they signed their own papers, and it got approved with no RFE, just like all the other founder H-1B transfers and concurrent H-1Bs that we filed in this administration. So I feel very positive about that. I think it's a good sign that all of the H-1Bs for folks already in the United States who want to be founders will be able to proceed as we discussed on the viral webinar that I did in summer regarding H-1Bs, which is available on our YouTube channel. And I think it's still a great resource for how to think about founder H-1Bs, CEO H-1Bs, H-1Bs for people who own 100% of their companies, concurrent H-1Bs, transfer H-1Bs, all of that, IP considerations. So that's available on our YouTube channel. Let me see if I can find that link, and I'll pop it into the chat for you. But that's pretty good overview, except yeah, it was called laid off on H-1B. 2025 self-sponsorship rules explained how to stay in the US legally. It's on our YouTube, and I'm going to put that into the webinar chat for you. So that webinar is from before, there we go. It's from before the $100,000 fee proclamation and the government shutdown, but everything else still seems to be functioning, like I said in that webinar, which is really exciting. Especially because so many people have like the urgent need to build their AI ideas right now in this time of rapid change. Okay, wait a minute. I want to go back. There we go. Okay. So the H-1B proclamation, its impacts, things that are still open questions include who has to pay the fee, when they have to pay the fee, how the fee will be paid, how the national interest exception works, whether the people in the US right now on F1, like regular F1, CPT, OPT, STEM OPT, whether if their employer is doing a change of status to H-1B, if they're selected in the lottery, whether they will be subject to the fee. There's a strict reading of the proclamation. This says it's only going to apply to people doing consular processing of their H-1B. But then it leads to questions like, well, great if employers don't have to pay for them, but what about when they travel? Does the fee kick in before consular processing and visa stamping? There's still a lot of open questions, but there's hope that recent graduates in OPT will not be subject to the fee if they're in the US. We're still waiting to see how the H-1B lottery is going to shake out with the new proposed rule that's in progress regarding the additional points for people who have a higher wage. So I don't know if you remember this, but before, a few years ago, people would game the system because you were allowed to file multiple H-1Bs for a candidate. The more job offers they got that sponsored them, the more chances they would have to get selected in the H-1B lottery. And they removed that through the electronic filing system and some new rules a couple of years ago. So it's one person, one chance. They're going to basically change the rules back to having one person, more than one chance in the Department of Labor FLC wizard where you can figure out the SOC code and the prevailing wage. There are wage levels. Wage levels 1 is the lowest for new grads. Wage level 4 is the most expert and senior. So basically, if a company is going to offer a wage level 4 job to a candidate, they will get 4 chances in the lottery, 4 lottery tickets, like raffle tickets. And if they're wage level 1, they'll get 1 ticket. But I believe it was Tata, the Indian consulting company, they just announced that they're not going to be engaging in H-1B sponsorship anymore. And I believe they typically file in the tens of thousands each year for H-1Bs. So maybe other consulting companies will follow suit, but there may be less. The administration's push to decrease utilization of the H-1B lottery program by consulting companies looks like it's having an effect, whether the changes hold or not. And therefore, there may be better chances than ever for people working at early stage startups that the H-1B lottery might become worth it for them to participate in. So it's an interesting shift. So that's the H-1B proclamation, recent case study examples. Because at first we knew that an extension for the same employer would not be subject to the fee, but we didn't know if transferring it would be considered a new petition, but it is not. So that is really exciting. Talked about the government shutdown, talked about the H-1B lottery. 01, are there any 01 updates? Not really. Thank goodness. The 01 remains pretty stable. There's been a few RFEs, but we've been able to win all the 01s, so even with the RFEs this year, knock on wood, so that's pretty exciting. And the 01 typically remains the most straightforward way to get into the US and work at a startup if you're outside the US. 01s with agents are still working. That's where you get a company to sponsor your petition and you're allowed to have multiple streams of income, self-employment, contract work, side gigs, in addition to a main company or just a variety of projects. So that's still been pretty effective. For EB1 and EB2, for founders and researchers, we're seeing very high success rates, but the thing is, you have to be legally work authorized to be working in your endeavor already. They're not looking at it positively if it's a future business plan for like after you graduate and get work authorization. You kind of need to already be working in your startup and have traction and maybe some initial funding. And then the EB2 NIW is super straightforward, or be a researcher working in a university. Those are all pretty stable. For the EB1, we're getting approvals. We're getting approvals after RFE. It's possible still, but the RFE rate has just skyrocketed across the country. If you guys are shopping different providers, you might know more than I do about different approval trends for different companies, but or different law firms or providers. But I saw somewhere that the approval rate was like below 40% now. I think ours is still that we're winning, the vast majority of cases. But a lot of the RFEs don't even make sense. Like I've had to have this conversation multiple times this week with really brilliant, accomplished people. Like I know a few years ago, we were able to help a lot of, engineers in big tech get H-1Bs, but I'm talking about like people with 100,000 person networks and multiple awards in their countries at the national level, or like a top AI ML researcher at one of the Mag 7s where the company was petitioning them. I still have to tell, like even those company sponsored petitions are getting NOIDs now sometimes, and so I'm having follow-up conversations with people like, straight talk, I can do this for you. We'll give you as strong of a chance as we can. But even if you're, Einstein, that doesn't guarantee that you're going to get an EB1 in this environment, because it's such a volatile adjudicatory process with different ways of enforcing the standards that were once so clear. And if you had these level of qualifications 2 years ago and you'd come with me, I would have said it's like a 99% chance of success. But now the truth is, like, there's a lot of screening and volatility for EB1. And then the other change possibly on the horizon for EB1, EB2 is talk of the gold card. Still not clear how or when that's going to happen. There's been a lot of comments that are kind of at odds with the law, so it's unknown how that's all going to play out. The latest thing from the September announcements was that they would somehow I think it's in the White House executive order on whitehouse.gov, but it was talking about reallocating visa numbers from EB1 and EB2 to the gold card, which you kind of can't do because of the law. But what you could do is you could say, okay, if somebody has $1 million that they earned, that's proof of their extraordinary ability, and I'm going to give them an EB1. And if somebody else is investing $2 million or giving them $2 million, then I also think that's proof of their extraordinary ability. Somebody's vouching for them at that level. But even if USCIS did interpret having $1 million through your own earnings as equivalent to a one-time national or international award, those gold card holders would still be subject to the employment-based visa bulletin backlogs getting a priority date. So I think based on the way the law is now, all the current people with a priority date from India from 2014 or whatever would still be at the front of the EB1 line ahead of the gold card people. And then similarly, there was like one line in the White House, what's it called? It's the regulatory agenda for spring of 2025, which was actually published in September or October of 2025, late. There are a number of related immigration-related notice of proposed rulemaking summary paragraphs, and one of them on one line did suggest that there might be changes coming to the I-140 as it relates to the EB1A for extraordinary ability and the EB2 NIW. So I've been telling that to people in my consultations over the last 2 weeks, kind of from the perspective of, we don't know what that change will include. There is no indication. It could make it harder for everybody. It could make it easier for the gold card. It could make it easier for AI, crypto, and other like national security priorities. Or they could never follow through, and they don't, and then maybe they won't file a notice of proposed rulemaking related to I-140. So it's a very volatile time. The only thing we can count on is change. We don't know which direction the change will go, although the landscape is incredibly volatile with a lot of RFEs, NOIDs, and denials for EB1A right now. If you might be qualified and you have a current priority date, even if there could be that government scrutiny, you always have the choice to withdraw, but maybe it's worth it, depending, right, to have a chance and file now while we know the state of the law instead of waiting because it all might change again. So that's how I'm thinking about it. But of course, you know, every time you make an immigration decision, it's unique and it has to be personally correct for you and your family and your business and your colleagues. But that's just some general guidance for what I see for how people are thinking about it. You know, but I am seeing greater demand than ever for people to build in the United States. So we are the best place for you to have a startup, especially an AI startup. Being in San Francisco is, or Palo Alto is almost necessary. And there are a lot of pathways. Lots of people came for SF Tech Week. Lots of fundraising going to be happening between now and probably Thanksgiving, with lots of founders raising funds and being able to file for O1s or EB1s or EB2 NIW or other options. Even, you know, cap exempt H1Bs. I still have to find out how those are going with a partner organization that we worked with. But a lot is happening, and there continues to be a lot of business reasons of why it makes sense to be here and navigate this. And I talk with all sorts of people with, you know, name brand things you would recognize in the startup ecosystem. And it's still, it's always very important in a startup. The product is so risky. The opportunity is so great. The whole point of a startup is to de-risk everything except the innovation, right? And so getting the immigration sorted out remains to be a very, very important aspect. And I'm continuing to urge people to exercise caution regarding international travel, and if possible, limit it to, what only you consider to be essential. You're welcome to subscribe to our email newsletter. You can reach out to us. I'm able to offer as many consultations as are physically possible, and I'm looking at ways to expand my availability and my team's availability. We are professional services, not, a scalable software startup. So trying to do that as best as we can. I do have a bit of a wait list right now for getting a consultation with me. And we're probably going to be, historically, I offered to do a lot of complimentary consultations for people, but I think we will be beginning to charge a $150 fee. And I hope you find that, that's a valuable expenditure of your funds if you would like to talk with me. We do have our course, which I still recommend to a lot of people. A lot of people have taken it, become qualified for visas and green cards. That would be Alcorn Academy Extraordinary Ability Bootcamp. I'll put the link in the chat window right now. It's complimentary. It's on our website. About 1,000 people. I think it has I don't know. It has over 1,000 downloads. A bunch of people went on to get approvals from that and continue to do so. So that's the course. If you need us to evaluate very thoroughly your O1A, EB1A, or EB2 qualifications, we do offer, and you don't need a consultation to do this. With Legal Lunch, look, I'll just tell you, it's $3,800. It's 4 weeks. We give you our comprehensive 20-page evidence checklist for O1A, EB1A, and EB2 NIW. You have 4 meetings with my team, with your client journey coordinator and the associate attorney assigned to you. We review all your evidence. We do a comprehensive multi-stage gap analysis, and then there's an attorney consultation where we let you know how qualified you are for each of those case types or whichever ones you're interested in, with written recommendations on how to become more qualified. So if you're thinking about doing an O1A, EB1A, or EB2 NIW with us, and you already have a bunch of the evidence, please don't wait to get on my calendar. We would be happy to help you. You are welcome to just email my team, hello@alcorn.law, and say, I would like to sign up for Legal Lunch, and you don't have to wait to talk to me. And if you think you are qualified and you want to start an EB1A right away, even doing this is the best way to get started. Because then we're super confident that we have all the evidence we need before we jump into the letter of recommendation process. We're still accepting H-1B transfer cases for founders and concurrent H-1Bs. And the way we do that is we have a 2-phased approach. So there's a consulting period before the company is incorporated, where the foreign national can directly hire us just to figure out the roadmap for funding hours, SOC code, prevailing wage, investment tranches, whatever you're figuring out. And then we'll work with your corporate attorney to make sure that the company is formed properly from an immigration perspective. So that's phase 1. It's $3,000. Once again, you don't need to do a consultation to talk with me about that. If you're exploring doing your H-1B through your own startup or your own LLC that you have or something, if you're doing a consultancy. And then we move on to phase 2, which is the actual H-1B transfer, concurrent, et cetera. And that's when the company exists and the government shutdown is over. Then the company can engage us and pay our $6,250 legal service fee, and we'll do the LCA and help you with the posting and all those things to actually file for the H-1B. And then for a brand new company, the USCIS filing fees are $2,010 plus optional recommended premium processing, which is $2,805. And we can set up the whole thing so that you don't even have to give notice to your current employer until after you have the approval in hand. So there's a lot of ways to be cautious about that. But if you want to get an O1A, EB1A, or EB2NIW, you can simply retain us for legal launch without having spoken with me. And if you want to do some sort of founder, part-time, full-time, H-1B, transfer, concurrent, etc., and you want our consulting support with that, I don't have to be a bottleneck for you to engage with us. You can simply hire us for that $3,000 consulting phase. And then if you do want to, sign up and pay for a consultation with me, I think I'm booking 2 or 3 weeks out right now. We will ask you to complete our questionnaire. I tried to make it as simple as possible. You check as many boxes as apply, and then I, in the consultation, try to, discuss your goals. I ask you the magic wand question. If I had a magic wand and I could magically solve this for you, how would it change your life? What would you do? Why do you want to do it? Like if you had an EB1A I-797 approval notice in hand, what would that change in your life, etc., right? It's different for everybody. We go through your past immigration and professional history. We go through any evidentiary criteria, and then I try to answer questions like, what's my best legal strategy? How strong is my case? Should I apply now or later? Do I have to do anything else to become qualified? Our rates, our timing, and then I send you a follow-up email. So that's my process, but I am, booking several weeks out. So if you want an H-1B, an EB1A, an EB2NIW, or an O1A, we do offer those direct ways to engage with us, so you don't have to wait for me. And those analysis processes are designed to be comprehensive, because in a 20-minute call, there's only so much surface level analysis that I can do. And I want to make sure you have the strongest case possible, which is why I created those other consulting roadmap phases with the H-1B phase 1 and the legal launch. Okay, now we're going to go to your questions. Yay! Okay, great. So, and then I have our contact information. And I wrote a book, and it's available on Amazon and Audible. And I did the voice recording before there was voice AI. I am a real person, not a bot. I'm certifying myself. Okay, so now we're gonna go into the Q&A. Thank you so much for all the great questions. I'm excited to dive in. Okay, so here we go. The first question says that this person previously worked in the US on an H-1B approved in November of 2024. They lost their job, I'm very sorry to hear that, and later switched to B2, valid until December 14th, 2025. If I find a new job now or after leaving the US, will the new employer's H-1B filing count as a transfer, which would be exempt, or a new petition under the new $100,000 fee rule effective September 21st, 2025? I think it would be exempt. The new employer would not have to pay the $100,000 fee because you had an H-1B before September 21st, 2025. So any future transfers, extensions, concurrent, would not be subject to the fee. So you should be good, and this is being borne out by various approvals that we're seeing at our firm and friends' firms in the field. So if you still don't have a job by December 14th, you can file for an additional B2 extension for an additional 6 months. Let's say you get an offer, but there's still a government shutdown, then the company would not be able to file the LCA until the shutdown is done, unless they already have a multiple person LCA from a prior case they did. And then they could still hire you. So you may need to get another extension to buy more time, depending on the shutdown, even if you have a job. I think I muted myself in time. Thank you. Okay. Hello, everybody. Okay, answer live. Here's our next question. What is the benefit of an EB1A or EB2 over the O1 visa, and how to secure it through entrepreneurship, starting a business in the US from a Canadian science startup? Excellent. Okay, so anything with EB stands for employment-based, and it specifically refers to the green card pathways. So an O1 visa is a 3-year multiple entry status, which can be extended indefinitely in 3-year increments, where you're allowed to be in the US. If you get an agent, you can have multiple streams of income. And if you're married, your spouse cannot work. And some people want an employment-based green card so they can have permanent residence in the US, which is a lifetime status with 10-year cards, the ability to take a break from work, have a sabbatical, change careers, be a comedian on the side, whatever you're secretly wishing you could do. And then your spouse can work, but it has tax implications for your lifetime as well if you choose to go down the permanent residence route. So what most people from startups would do is they get an O1 first to move here in the next, 5 to 8 months. And then once they're here and settled and they reach more milestones, then they start with the EB1A or the EB2 National Interest Waiver green card process. EB1A is the fastest category for people born in any country. EB2 is super slow. It's insanely slow for India and China, but it's also slow for other parts of the world. Other parts of the world, it might take like 2 to 4 years to get a green card, where in EB1A, maybe it would take 1 to 3 years. So it's a different category. And you could have an O1 and then you could get a green card, or you could stay in Canada and just get green cards in a few years and then move here. But a lot of founders are on timelines where they would need an O1 faster than they can get a green card. Somebody asks, my lawyer says she has filed for my EB1C. I'm on an L1A 73 days ago, but we still don't have a filing receipt. Is this normal? Do I need a new lawyer? I would request, like what we do routinely after mailing out a package, because we have to like physically, print out all the pages and take it to FedEx or UPS, and we get it, we scan everything, we get a tracking number, we have checks with tracking numbers that we wait to see when they're cashed. So if your lawyer did file, then there should be some evidence from her bank account. If she paid with a check, then there should be a what's it called? When the bank shows you the check, and on the back it has the deposit information on it. You should be able to get your receipt number from that. If it was e-filed with credit card or ACH, there should be a bank tracking number for that. She should have a courier proof of delivery or like postal service certified mail. So I think at this point you should absolutely request proof of filing from the attorney and see what happens there, because it may be lost in the USCIS mailroom, but also there should be some sort of proof that something was sent. And then if it was receipted in, like if there's a fee receipt, if it shows that her bank account was charged, then you definitely know it's been received, and then you know it's a USCIS issue for not sending the receipt notice. I previously worked in the US on an H-1B approved in November of 2024. I lost my job and I later switched to no, wait, we did this. Sorry. Can you change your status from F1 or any other visa back to H-1B if you have days left on the previous H-1B by self-sponsoring? Yes. Most people would not do this unless, okay, let me take a step back. Sometimes the reason that people switch from H-1B to F1 is because they are near their H-1B max out and they didn't have an approved I-140, so they're not yet eligible for AC-21 extensions. Another reason would be that somebody worked for a couple of years and then they got into an MBA or grad school, and now they're back in grad school and they didn't use all of their first H-1B, which was valid for up to 3 years. If you have any time left on H-1B at all from before, you can absolutely transfer and change your status back from F1 to H-1B, and you would not be subject to the $100,000 fee to do that. You do need to check how much time you have remaining, because if you only have days left out of the entire 6 years and you don't have an I-140 approval yet, I would wait and not utilize your H-1B until you get an I-140 approved. But if you only use like 1 to 3 years of H-1B time, it's totally fine and you have years remaining. Would the Oh, I spoke to this. We're still not sure if the new 100K fee will apply to F1 students doing a change of status from F1 to H1B after next year's lottery. It is still unclear. I have hope that you will not be subject to the fee, but we're still waiting. Does USCIS still use Dun & Bradstreet data for scrutiny purposes? Yes, they do. We walk you through that in our consulting phase. For an O1 application sponsored by a newly registered nonprofit entity, what would be the requirement of budget and funds raised by the nonprofit to support the application? This is something we would do in our H-1B phase 1 consulting. At minimum, the company has to pay the prevailing wage for the number of hours that the foreign national will work in the specialty occupation, in the wage level, in the geography for the chosen job, and we help look at your job description to figure out what that would be. There is no nonprofit exception to the $100,000 fee, but certain nonprofits might qualify for a national interest exception. I am still waiting to hear back about whether those have been. I'm just gonna text my friend right now, actually. Let's see. Hey, any updates on changes of status filed with EP post 9/21 for new H1 fees? Thanks. Maybe she'll respond during this webinar. We will find out. Okay. Next up. Regarding the EB-1A priority date, how long before it becomes current? How do you know if the administration would be introducing any amendments? Okay, if you're not from India or China, it is still current. If you are from India or China and you've never gotten an I-140 before and you don't have a priority date yet, it's kind of unclear whether it's going to be like 2 to 5 years or something, but nobody knows. I think Didi, who blogs a lot and tweets a lot, and I did a webinar with him, he was my client. I think from time to time he publishes analyses of like the total wait time for new Indian EV1s, but I don't know the latest. And then I mentioned that there was that notice of the White House regulatory agenda that might affect the EB1 process in the future, but we don't know if and how. Oh, this is amazing. They filed 3 last week and have receipt notices for 2. No issue so far. Change of status from 03. That's amazing. Okay. Okay, so what that means, amazing, thank you. That's great. Okay, so I just did the question for the nonprofit a minute ago. So the nonprofit would need to figure out if it can qualify for a cap exempt H-1B, but let's assume it can. And let's assume the foreign national is currently in the United States on F1 or O3 or H4 or something else. It appears that it is possible to get a change of status done right now for an initial H-1B for somebody who is not outside of the country without needing to pay the $100,000 fee. So that's amazing. Good, glad I was able to get that during this webinar. Now I don't need to follow up. Okay, next up. What are the newest updates for the green card lottery? If one applies for the green card through the lottery, can one still get a J1 visa in the meantime? I haven't been tracking the green card lottery closely. I don't know if there are any updates. I haven't seen anything come across my desk. I think there have been people who have gotten J1s after they've put themselves in the lottery. The key to J1 is non-immigrant intent. We are getting a lot of J1 research scholars for people to work at for 5 years in AI/ML startups as private employers. That's not a lottery type of visa, so it's very effective if somebody has non-immigrant intent and wants to go back home. You can also transfer your J1 research scholar from a FANG to a startup. We're doing that as well, even for co-founders. So there's a lot of possibilities with J1. I mean, it might be best if you have the flexibility to apply for your J1 before you put yourself in the green card lottery, if you have that option. But if you already put yourself in the J1 lottery, if you already put yourself in the green card lottery, you still ought to try to apply for a J1. And let's see, okay, great. Yep, all good on that front. Okay, that's amazing. If somebody has time left on their H-1B because they left the country and are back, would the recapture of their H-1B time incur the $100,000 fee? The answer is no. Congratulations. Somebody has the offer to be a chief technical advisor for a startup willing to sponsor a concurrent H-1B. That will not be subject to the $100,000 fee as far as I can tell. So that's great for you. Does the $100,000 fee apply to an H-1B founder, beneficiary owner if they apply as a part-time position? Nope, it doesn't seem to be, which is excellent. How can a person on an F1 visa create a startup and what can they do actively in it? Okay, well, the first step is to ask your school if they offer sponsorship for part-time pre-completion OPT during the school year, full-time pre-completion OPT during the summer, CPT during the academic terms or the summer. And you have to be beyond your first year to get any type of work authorization unless you have extreme financial hardship. So a lot of people in their second year of their master's would get part-time pre-completion OPT, and then they would use that, which reduces their regular 1-year post-completion OPT at a 50% rate. So if you get, what is it? It's October. Let's say you use premium processing and you apply for 6 months of part-time pre-completion OPT from December until you graduate in May. That would subtract 3 years from your post-completion 1 year of regular OPT, and hopefully you chose a STEM degree, and then you would still have your normal 2 years of STEM extension. So you'd have to track your deadline and your expiration separately for the regular OPT because it's going to end earlier than your friends after you graduate. But if you have those work permissions, you're allowed to legally work on your startup, become famous, get an O1, et cetera, et cetera. But if you don't have work authorization, you have to be extremely careful. Some schools have classes that specifically require you to do like startup idea validation and user testing and, research, talking to potential customers or investors. But you have to be very, very careful about this because normally on an F1, you're not authorized to work. And the way the government has historically defined that is labor or services in the hope of future money. So there's certain things that you absolutely cannot do, like get paid as an employee or, do code for like a sign-on bonus. But there's a lot of gray area, and I look at what is possible on a B1, B2 visitor status, like, oh, okay, it's not work if you're like having coffee with a person who ultimately decides to invest. That is an okay thing to do, but you ought to be cautious, please, to not work without authorization. I'm on an H-1B visa and I work remotely, so I'm thinking of relocating from California to the East Coast. What should I make sure I do or not do with my employer, USCIS, LCA, etc.? You'll have to get your employer's permission and they will have to amend your H-1B and it will require a new LCA, and you will need to do your AR11 and online address change with USCIS, and your employer can't effectuate the change until you have your future address if you're working from home, and you're going to have to do the LCA posting in your home. So it's probably a good idea to start talking with your company about it, see if they have an office you can work from, figure out where you would live, and then you're gonna have to coordinate with them to do it. Can law students or lawyers qualify for an O1? If so, is it A or B? It's very difficult because the O1B is for artists and the O1A is for like business, science, education, engineering. Basically, if we're gonna get an O1 for a lawyer, we have to do it in a business field related to the law, not directly for being a lawyer. Somebody had an H1B through the lottery that got revoked in July of 2025. Okay, they only used 2.5 years. They're on TPS now. Can you go back to H1B without consular processing and without $100,000 fee? I believe so, but the only way to know for sure is to try it. But I was just looking at it depends. It depends on when you entered and if you had unlawful presence and if you need to travel and if you ever had advanced parole. So that is quite complex. And if you seriously want to consider it, then it would be a paid consultation with me. And ideally, your new employer would be in there and you would give me as many materials as you have well in advance. So we can try to look into it. Having co-founded a company, can a person file for an O1 visa? Yes. What are the requirements? The O1 is based on 8 criteria. For example, have you won awards or prizes? Are you a member of organizations that are hard to get into? Did people write articles about you? Have you invented something interesting that's impactful? Do you have a leading and critical role in a distinguished organization? Did you make a lot of money? Did you write stuff? So that's kind of the overview. There's a lot on my website about it. Now we have a German citizen interested in opening a business in California, exploring the E2 treaty investor visa and the type of company. It very much depends on the type of business. If you want to do a startup, the E2 is not the way to do it. If you want to have like a lifestyle business that you're self-funding, that's just getting started in America, and maybe your spouse needs to work and you're going to be able to put in like $100,000 and you don't need to transfer any employees from Germany, then the E2 is great. But if it's a venture-backed startup, if you need to be able to work at other jobs, if you have non-German employees in Germany that you need to transfer to your US office, then it's not the right situation. Happy to chat further. Can an L1 be used for a profitable company that's not erstwhile? What does erstwhile mean? I don't know what erstwhile means, you guys. Sorry, former. Oh, okay. Former. Oh, the company was profitable before, but it's not doing revenue. Maybe we might have to argue that it's a one office, a new office, 1 year, L1. I've applied for an H1B visa extension before the new executive order, and I'm thinking of going back home to get a visa stamp. Are there any news about people like me who went back home to get a visa stamp when they were asked to submit the fee? No, you can just go do the stamp now. You can just go do the stamp. You just get an appointment and go do the stamp, and it should be fine. When applying for the EB2 NIW, while being on an F1 visa, can one leave the country and re-enter, or does one have to stay in the US? It is very difficult to leave and re-enter because self-petitioning an I-140 could be construed as evidence of your immigrant intent, therefore making it impossible to get an F1 visa stamp again and potentially subjecting you to questioning upon re-entry. So usually we urge caution unless you absolutely know this will be a temporary entry on F1 again. And you can prove it. Somebody is on the O1 visa since January. Congratulations, there's a change of status. They want to switch employers and they need to do an O1 transfer. What should be the start date on the new O1 if they have a 2-week notice period for the current company? Should you put in your resignation? When do you give notice? We do this in a lot of different ways depending on what the person's next step is going to be. You can file for a change of employer petition up to 6 months in advance. You could also file for a concurrent O1. So if you don't want to give notice and you want to see if this will get approved, you could file for a concurrent O1 with an agent, or you could file a transfer to your future employer, but choose a start date, like, depending on your comfort level, 2 to 8 weeks out from the date of filing, so that once it gets approved, you still have time to give notice and you're maintaining status. Is the government shutdown slowing down biometrics appointments and H-1B visa processing times? It is not slowing down biometrics. It is slowing down H-1B visa processing time simply because the LCA cannot proceed. My previous AMA of September 27th is not going to be available on YouTube, but I appreciate the request. Has an NIE been announced for the H-1B $100,000 fee? No, it has not yet been announced. The one thing in like a Truth Social or something from the White House from like the 23rd was that doctors might qualify. But I think anything like crypto, blockchain, AI, ML, semiconductors, like anything in the national interest would probably qualify. Would I recommend speeding up the process when applying to an O while it's still stable and visa reforms happening across the board? Yeah, for a qualified candidate, absolutely. And also, let's make sure you're qualified before we file. How much do O1 agents get paid? I've seen all sorts of things like up to $5,000. The agency I use, I do not own. I do not get a referral fee from. I just recommend people to them. They charge $1,000 per 3-year petition. I've applied for an H-1B visa extension in early September. I received an RFE to do biometrics by November 20th. I haven't received the biometrics appointment letter. Other employees received the appointment letter 1 month after the RFE was issued, and the appointment was 2 weeks after receiving the appointment letter. What happens if I end up receiving an appointment after November 20th? Shall I go online and communicate with USCIS somehow? Yeah, I would call their customer service number and just try to figure out what's going on. And maybe the letter got lost, or maybe they've sent it recently, but I think it's good to ask. I previously worked in the US on an H-1B approved in November 2024. I was laid off and I later switched to a B-2 valid until December 14th of 2025. Okay. I think I answered this one. You don't have to pay the fee. Can someone with a university cap exempt H-1B visa transfer their H-1B to their company as a founder? Only if your company is cap exempt. But if you're going to continue to have a formal affiliation with your university, such as working in your same lab doing open source research with a formal affiliation agreement between your startup and your university, then your company could qualify for a cap exempt H-1B for you, and you don't have to go through the lottery. Or we can work with a partner nonprofit to get you an H-1B without the lottery. Or you could keep working at the university part-time and then add on a concurrent H-1B for your startup, and then also put yourself in the lottery. Oh yes, I should have made this clear. If you do our legal launch program and then we find there's some gaps, typically we are willing and able to apply the entire $3,800 fee to your next case within 6 months. And then we can offer one follow-up written analysis if your evidence changes within 6 months. Somebody is laid off. They're on their 60 days for H-1B. What's the latest on the H-1B transfer and timeline given the government shutdown? LCAs can't happen. So try, interview, get an offer, work with the company, have everything ready, but you might need to have you or them file a change of status to B1 or B2 as a bridge if the H-1B transfer can't be filed within the 60-day grace period. Who is eligible for an O1 visa? That's where you have that extraordinary ability at the top of your field or subfield in a country or in the world, demonstrated by meeting 3 out of the 8 criteria, often used by founders, researchers, etc. And it normally takes us 12 weeks to prepare and file a strong O1 petition. USCIS premium processing takes about 3 calendar weeks, and then visa stamping in your home country takes about 1 to 2 months if you're not seeking a change of status. I'm currently on an H-1B in Tennessee. If I get married to a US citizen in California, how soon can I move to California? Can I abandon my H-1B visa pending the green card approval? How long will it take for me to get a work permit? Congratulations. As soon as the I-485 is filed, you are maintaining valid status independent of your H-1B. So if you wanted to quit and move to California the day after you have that receipt notice, and you would abandon your H-1B, you're allowed to do that, but you wouldn't be able to start working until months later when your EAD comes in the mail. I have my I-140 approved. Will I be eligible for an L-1B unlimited extension? Or am I limited to the 3 + 2 years rule? Unfortunately, there is no provision for unlimited extensions for L1s. That is only for H-1Bs. The L-1B is limited to 5 years, but your employer should put you in the H-1B lottery because then you could get unlimited extensions. My F1 visa is expiring in June of 2026, and I'm planning to apply for an O1. If I get its approval by or after June of 26, then does my employer need to file a cap exempt, since it might take some time for the change of status from F1 to O1? If you're talking about an H-1B, I mean, it might be good to have an H-1B in the lottery as a backup if you have a company willing to sponsor you, but hopefully you would be eligible for OPT and STEM OPT after your F1 to bridge the time to your O1. But if your F1 time is running out and you're not ready for an O1, then you would need to bridge the gap with a B1, B2 potentially. If somebody wasn't selected in the H-1B lottery this year, will the fee apply to them if they're applying as an F1 next year? Hopefully not, simply because you're already in the US. Here's somebody who's a founder and advisor of a nonprofit and had a full-time H-1B employee at a tech company. Oh, they are a full-time H-1B employee of a tech company. They want to transfer their H-1B to the nonprofit to help it grow and possibly move to O1. Has it been done before? Yes. Is it viable and feasible? Absolutely yes. Happy to chat. We can do that phase 1 H-1B program if you would like. Can an F1 student with CPT take an equity-based startup role or equity-based with little or cash role? Probably not. This would have to be explicitly approved by your school on the I-20 in CVIS, and you'd need the company to give those details to the school to get it authorized, but maybe they could do it. I think it doesn't matter to the school how you're being compensated, but you just need to get it all authorized. So some schools will do it, some won't. Can I be on H-1B and get an O1 for a startup that I'm a co-founder of? Cannot really quit the current job until we go to series rounds. What is the best option, concurrent H-1B or O1? It's usually adding on a part-time concurrent H-1B right now to help you get through fundraising and to help you be able to work legally. So in the future, when you're ready to apply for O1, you can show that you had legal work authorization for any initial startup activities. How long does it take to receive a filing receipt these days? Usually 2 to 3 weeks. Isn't USCIS to send one within 30 days? Usually yes. What's the best path for an F1 visa holder currently on OPT to obtain a green card or citizenship? Getting a priority date through an EB2 NIW self-petition is very helpful, but then also getting H-1B lottery sponsorship and paving the way for an O1 is very important. Being mindful of immigrant intent once you file the I-140 because it can limit travel on F1. Currently laid off on my 60-day count on H-1B. What's the latest on the H-1B transfer and timeline given the government shutdown? Will I be eligible for the special cases declared by USCIS today? I don't know. That's the first I knew about this. Sorry about that. Let's see what they put on their website. News releases, Venezuelans. Newsroom. Oh, well, okay. I don't know what you're talking about. Sorry, I haven't read it yet. You're welcome to email it to me and I'll take a look. I do see breaking news. USCIS implements new immigration parole fee required by HR 1. What is that? $1,000. This is in the government shutdown. I don't think this applies. I'm sorry, I don't know what you're talking about. I haven't read about it yet. I don't know if there is any special cases thing declared by USCIS today. Yeah, I probably would recommend if you have the money to file a B2 as a backup. There's, so much going on. Is a mechanical engineering degree, a recent graduate on June 10th in the space business startup in Canada and wanting to start it up in the States, sufficient and qualifiable for an O1A, EB1A, or EB2 NAW. Maybe an EB2 NIW, but you're also going to have to worry about export control rules and controlled technologies. So this would be a thing to talk about. It depends on how much startup success you've had in Canada so far. Thank you for the well wishes. I very much appreciate it. Thank you for the kind words. I very much appreciate it. Thank you so much for being here today and staying with me. And I hope you all have a wonderful rest of your day. Bye, everybody.